taxpayer know the key points with the publication of the new PGFN Ordinance 2044, effective March 1st, 2025, replacing Ordinance PGFN 164 March 1st, 2025, and replaces Ordinance PGFN 1.64 1080 percentage. Our guests today are the renowned Paixão, legal manager of insurance at Pottencial, an insurer that has been leading the surety insurance market for the past 7 years. With 15 years of experience in the market, Pottencial was founded with the mission to simplify and automate the surety insurance issuance process in the country, as well as to support its partners throughout the entire journey. Lawyer, member of the Credit and Guarantee Commission of FEMSEG, postgraduate in Civil Procedural Law from the Fundação Mineira de Educação e Cultura, extension course MBA in Insurance, including Surety Insurance from the Business and Insurance School, Leadership Training from Fundação Dom Cabral, and Strategic Management from INSPER. Rafaela Ramalho, Legal Manager at Junto, the most traditional insurer in the surety insurance segment, which has led the market for the past 3 decades and has played a key role in dialogue with public insured parties through the presidency of the Technical Surety Insurance Commission of FEMSEG over the last 10 years. This year, Junto is also celebrating 30 years since the issuance of its first surety insurance policy. Rafaela graduated in law from Curitiba and has nearly a decade of experience in the surety insurance market. Cássio Amaral, lawyer and partner at the law firm Machado Meyer Advogados. Cássio is one of the leading references in surety insurance in Brazil, graduated in law from the Federal University of Bahia, with a master's degree in administration from the Federal University of Bahia, a Master of Laws from Emilion Business School, and is a qualified lawyer in Portugal, the United Kingdom, and Brazil, currently pursuing a doctorate in business and innovation at GV. Thank you for being here. In Block 1, we highlighted the changes. Now, our interest is from the taxpayer's perspective to evaluate what they need to pay attention to in this new. I think there's an important first change where the standard clauses greatly favor the back and forth with the judiciary and the attorney's office regarding the acceptance of the guarantee.
Certainly, Carol. I think that the ordinance brings a great deal of legal security for the taxpayer. From the moment it introduces a standardized clause, we eliminate that initial stage, present a policy. The attorney's office finds that the text is not suitable for what they want, returns it, and we go back and forth to adjust details of the product's text, which was already a well-established product for many years. But even so, we often had difficulties with acceptance. Now, with the standardized clause, insurers following exactly what is stated there. The expectation is that the taxpayer will no longer experience delays in the acceptance of policies, meaning it will be faster and more efficient.
Another important change is the anticipatory one, which now can be done in a much more fluid way without needing to go to court. I think it will make this bridge.
Exactly. What happens today is that many taxpayers are left in limbo between the moment when their case is eventually processed and judged administratively due to their infraction. And then they spend some time in limbo because of what? Because they are sometimes registered as having outstanding debt or are under the threat of being registered as such. Until the execution is filed against the taxpayer, this takes a long time. And sometimes the company usually needs a clearance certificate. So before, now what happened? The taxpayer files a lawsuit, is forced to take legal action, asking the judge to issue a certificate, presenting a bond or another suitable guarantee. So in theory, they won't need to make this move. He can administratively, through the regularized platform, present a surety bond so that immediately, and we will discuss a bit here how this can be operationalized, he can obtain a clearance certificate extrajudicially.
So on one hand, it's interesting because it even reduces the cost of not having to file a lawsuit. But there are also some nuances regarding the deadlines that need to be observed by the taxpayer.
Perfect. From the moment the taxpayer submits the request on Regularize, the attorney's office has 30 days to evaluate the request and then decide whether or not to issue the positive certificate with negative effect. And then we have a point where actually we need to understand how the attorney's office will behave in this new situation. Previously, we had the court evaluating this request, with lawyers working there even in person, right, Dr. Cássio, to expedite the granting of the injunction and the issuance of the certificate. And now we have a 30-day period that could be lengthy. We don't know. Depending on the client's situation, it might be... And we also don't know how the attorney's office will handle this volume. We hope that with the regulation, they have obviously prepared for this. But there might be an increase in volume, a difficulty in handling all this new obligation that the attorney's office has. And then, thinking positively, I don't believe they have implemented something they can't manage. But we will have to see in practice how all this will unfold from March 1st, but I see it as a positive, very positive change. And taking a cue from this, we have the Surety Bond as a possibility for full debt guarantee, but the ordinance also brings us an innovation for the taxpayer that is quite interesting. We know that the Surety Bond market operates with a credit limit, let's say, so the policyholders have an issuance limit within the companies. It's usual, we know how it works, but if a taxpayer is unable to issue the full amount of a tax execution, which sometimes involves astronomical amounts, they can use an asset, another guarantee, and also the surety bond in a complementary way. And then he reduces his cost. The surety bond is the best option we know due to cost, due to ease, but it's not always possible. And then he can manage this according to his interest with the lawyer's guidance. So, very positive. And another advancement, the attorney's office got it right?
Certainly. It's important that the insufficiency in presenting a guarantee needs attention, as it does not release the certificates and the registration in KDIN. But the complementarity of guarantees reaching the required value is uma very interesting innovation and can indeed reduce the burden of presenting guarantees. Another aspect that I think is important to emphasize, which was already provided for in PGFN 164, but practice shows that the lawyers handling the cases continue to include the additional 30%, and there's a reinforcement, reinforcement in which Ordinance 2044 emphasizes that there is no need for the 30% increase provided in the CPC.
Yes. We have been hearing a lot from clients, from taxpayers, this concern about the extension of the term regarding the increase in the cost of the guarantee insurance due to the term from 2 to 5. But on the other hand, it puts a cap, so to speak, on the 30%. The 64 was from 2014. In 2015, we had the CPC, the Civil Procedure Code, which left some doubt as to whether there was an overlap or not with the ordinance, since we are talking about a law. And now the ordinance addresses this issue, resolving it. So the 30% is not needed, and it balances out what is good and bad within, not bad, less advantageous.
Regarding this issue of validity, I have a particular opinion from the taxpayer's point of view that the nature of the automatic renewal product, where the policy attached to the process guarantees until the final judgment, regardless of renewal, that the non-renewal of the policy before the start of validity, before the renewal date, triggers and characterizes the claim. There is such great security for the PGFN that I question whether it would be necessary to extend this period to 5 years, and if this reinforcement could actually contribute to a review of the 2-year minimum period provided in PGFN 164 to 1 year. So that each year he would present a new insurance policy. I think it would be beneficial for the entire insurance chain, because it would bring diligence in monitoring the quality of the borrower's credit. From the insurer's point of view, it would be less burdensome from the taxpayer's point of view, and most importantly, it would allow him to renegotiate terms and conditions annually based on the improvement of his credit quality over time. Really, over 5 years, my perspective is that not being able to review the terms and conditions of your policy contract for 5 years is quite burdensome for the taxpayer. We even made a contribution to the public consultation with this point, suggesting that either the 2-year period be maintained or perhaps reduced to 1 year due to all the other instruments that may reinforce the liquidity of the instrument for the PGFN.
Effect. And the curator markets actively participated in the BIPBAI public consultation in negotiations with the PGFN, and we presented this not only in the public consultation, but also in meetings with the attorney's office, stating that the surety bond, once it enters the process as a guarantee, will remain until the end, regardless of renewal, regardless of the 60-day compliance, which was a previous issue, regardless of renewal until the end of the term or the filing. In the process, there is no type of event except for substitution by another guarantee accepted by the court that would relieve us. But the attorney's office was not flexible on this point, and we couldn't get through to the other side. Anna, do you know why they weren't flexible either?
Because they also weren't flexible. Let's understand. Under the aegis of 232 of the ZEP 232 circulation, the deposits had an expiration date and did not have automatic renewal. The attorney's office took quite a hit because after the validity expired, they were left without a guarantee. So they understand, I think, the current structure, but once bitten, twice shy.
She wants to have reasons to be concerned. But I think that for this point, the fact that non-renewal characterizes the claim already surpasses the issue. And then expanding the term to 5 years doesn't bring any reinforcement or benefit to the PGFN. And actually, I even think there's a point that would be unfavorable to the PGFN because due to the what is requirements established for the insurer. You have until the renewal date for regularization. So if it enters any special regime process at SUSEP and loses the certificates that are required, you have until the period. By the norm, being strict to the norm, you would have until the end of the term to make the substitution with another guarantee issued by another insurer, or eventually the substitution with another guaranteeing instrument. And 5 years seems like a long period for this purpose. So there would be a benefit for the PGFN itself if this period were reduced from 5 years to 1 year. The diligence regarding the solvency of the guarantee issuer would be there, fair. It would always be on top of the issue, because they would have a period of up to 1 year to regularize. I mean the guarantee issuer to regularize, or the taxpayer to replace it with another guarantee instrument, or with a surety bond issued by another insurer.
Carol, but there's a point here that I think Rafa will answer better, which is now how the pricing and analysis of counter guarantee is done vis-a-vis the 5-year horizon. In 2 years, the company changes up or down in terms of quality, solvency, etc. In a faster way. So a 5-year horizon is a horizon in any scenario in the world, a difficult horizon for measuring credit risk in the operational area. So I think this has an impact perhaps on the CCGs that will be signed with taxpayers, and maybe a pricing method as well, and the payment of additional premiums, and eventually creativity here, cashbacks. So the guy was terrible, turned into AAA. Why not negotiate halfway? I wonder if this won't affect pricing and counter guarantee a bit.
One thing I find extremely important that you're bringing up, Cássio, is that the PGFN allows the terms and conditions to be renegotiated as long as they do not affect the guarantee given to the PGFN. So this negotiation between the insurer and the borrower is possible before the PGFN However, we know that this is not the current market behavior. The market today behaves in such a way that during the renewal of the policy, there is a renegotiation of terms and conditions.
But it could be done like this. Tell me what happens with credit insurance.
Yes, some parameterization.
By setting parameters, look, you are still AAA. If you fall here in the ratio, it will increase by X, or eventually enter into periodic negotiations and allocate this discussion to the CCG. So I think it's a technique that you insurance companies could use to measure and not charge too much or too little.
Too little as well. Yes, and then I think from the insurer's point of view, it's about increasing or giving discounts based on that new credit reality. And if this were parameterized, it would be an excellent advancement to avoid burdening the taxpayer due to the extension of this term.
But regarding the term, I talked to the underwriting team, and we are discussing with specialists on the topic. And from the approval point of view, since it's 5 years, it doesn't change because we were already at risk. It's just not formalized, but we are at risk for even longer. We know that legal proceedings, especially the fiscal execution of federal credit, do not last 5 years. The insurer does not see this as a change. And speaking on behalf of the Pottencial, it does not see this as a change that could cause any harm to the taxpayer, to our clients, because we already assessed the risk within this long-term risk characteristic. It's an indeterminate risk, you might think. We just need the term for the purpose of charging the premium updates and all that. But anyway, it's a point that we did not see as a problem. Now, this issue of the rate now is really something to consider, and I think it needs to be discussed with the market. This discussion is not trivial. It needs to happen.
Another point, Carol, also for the taxpayer to pay attention to is that although the ordinance states that the renewal presentation can be done by the borrower, the taxpayer, or by the insurer, it is very important for the taxpayer to have a perspective on how operationally difficult this will be for the insurers, and that even though the ordinance provides this possibility, the reality will not operate this way because the insurer is not a party in the processes, and it has no interest in participating in those processes, even to avoid harming the borrower and the taxpayer in some way. So the presentation of the policies will still need to be done by the taxpayer, despite the ordinance providing the possibility for the insurer to also make this presentation.
This is a point that in practice catches my attention, especially regarding the choice of the partner broker, because I have seen practical cases where a new brokerage takes over, is appointed to represent a client before a group of insurers, and the insurers had made renewals, issued automatic renewals due to the lack of response from the policyholder, but not necessarily Manif, because the policyholder hadn't responded, but because the broker hadn't communicated with the insurer, and this communication was not effective. So that eventually, the same process was doubly guaranteed because during the renewal, they made the substitution, added it to the process. The insurer that had originally issued it was not notified, and then it carried out the automatic renewal process to comply with the deadlines that were stipulated in PGFN 164 and 164E. And then it takes time. Ultimately, this insurer that issued without knowing that the process was already guaranteed by another instrument, could even execute the CCG to collect the premium for that policy. So it's extremely important in this ED scenario, as it was in UMEI 4, but I think it's even more emphasized now, the importance of choosing your partner, the broker, to make this connection. Because the lack of communication now, previously, it was an issuance that you could eventually address this issue through negotiation. Now, you could have two policies being added to the process due to a lack of communication between the parties. So the insurer that was at risk might automatically renew and add to the process, and eventually a negotiation with another insurer might have been made by the policyholder without informing the previous insurer. And you end up with two policies added to the same process and potentially this entire system. Now, as you add the policy to the process, I imagine that the process of executing the CCG for premium collection is also more, if you reach the extreme of adding the policy, I also imagine it would be more, it's going to be more salary, right?
Yes, definitely. And the role of the broker is crucial to alert about these changes to bridge the gap between the insurer and the policyholder. Because there shouldn't be this break in communication. Exactly. Especially because the consequence of not presenting it becomes very serious, very well characterized as a claim within the regulation.
Carol, and we have another point, again, about the importance of the broker. Your role is fundamental as good brokers, which is about the insurance code, which is also an update of the regulation, which clearly brings the possibility of issuance in co-insurance, meaning two insurers guaranteeing the same risk. It outlines the requirements and then the attention that the policyholder must have at the time of renewal, checking the solidity of all insurers. Because if one of them is in a non-compliant situation, as we mentioned before, this policy will also not be accepted and it could result in a claim. And then the importance, once again, of the policyholder having good partners, brokers who will guide them in this regard. It's not just a simple renewal, it might require changing the coinsurance structure for the policy to be effectively accepted. Another point of attention for the policyholder.
This is a change, I think. The 662 really reinforced it. I believe it gave a lot of freedom and greatly motivated both public and private policyholders to revisit governance and diligence in the selection of guarantee issuers. Here, the new ordinance brings a very harsh and clear consequence that any co-insurer, or in this case, if issued by a single insurer, if it no longer meets the requirements, and by not meeting the requirements, we can talk about the solvency criteria that are provided, but also if it has a claim related to another policyholder, another client of the insurer, and it is prevented from issuing for 180 days from the date of default in payment, it can, until regularization. Yes, go until regularization and give regularization 180 days, right? From regularization, 189. It impacts by other clients that it may have supported over the course. So, today, just to conclude, when we analyze which issuers of guarantees would be accepted from the taxpayer's point of view, I think two perspectives need to be observed. So, solvency, right, we look at this aspect. And another aspect is the history of claim settlement, of claim payment, because both aspects can ultimately cause a policy to be claimed. And if he doesn't have the possibility to replace it with another surety bond, he may actually have to make the deposit to avoid having his policy claimed. And after the deposit is made, it is no longer replaceable. Cash resources will no longer be replaceable by another instrument. This can be a very costly consequence, and the choice of the guarantor becomes quite relevant.
And this point of not being able to use the surety bond in these cases, already having the seizure or auction scheduled for the transfer of a certain asset in favor of the attorney's office is interesting. I think the attorney's office has been setting rules based on the challenges it has faced over time. And that's right, we also understand the side of our insured, as our role is to provide security for all parties involved. Not only thinking about the borrower, but also about those who will use this guarantee.
This point about not being able to make a substitution after the process has already been secured with money is important regarding the taxpayer's agility in establishing another guarantee, because once it is secured with money, they will no longer be able to make the substitution. So it's important for him to already, and then there are all the measures for him to anticipate this, and everything we discussed about this procedural ease of anticipating the presentation of the guarantee and ensuring that he is not disadvantaged by not being able to make a substitution in the future.
One last point, I think even Dr. Cássio, that we need to evaluate, the taxpayer needs to evaluate regarding the compliance with deadlines. When the guarantee is provided, without another existing process, it is provided for the purpose of execution embargoes, without there being another action to discuss that debt. If the lawyer misses the deadline for filing the embargoes, the execution will also result in the occurrence of the claim.
We talk about the final judgment, but missing the deadline for the embargoes is also a trigger for the claim.
Rafa can contribute to this point because there was a conversation with the PGFN.
Initially, there was concern in the market about this possibility of the PGFN bringing the possibility of executing the guarantee with the loss of the embargoes and not clearly presenting a scenario of final judgment. But there was a conversation with the PGFN, and they made it very clear that, in fact, what they want is for there to be no pending appeals for judgment. Once there is nothing else pending, then they could execute the guarantee. So it became clear and settled in the understanding of what the PGFN's intention is.
Great. We covered the main points. From the taxpayer's perspective regarding the new PGFN Ordinance 2044, it comes into effect now on March 1st, 2025. In effect now on March 1st, 2025.